If a burglar gets hurt while trying to steal from you, can the burglar sue you? In short, yes, this is America. You can sue anyone for anything. The real question is, will the burglar win? Texas law is very clear that a burglar cannot sue you except in very limited circumstances. In fact, the law has been in effect for over 20 years now. Under a provision in the Texas Civil Practice and Remedies Code, a claimant who has been convicted of a felony or misdemeanor may not recover damages for an injury sustained during the commission of the felony or misdemeanor if the injury would not have been sustained but for the commission of the crime. A person is considered convicted in a case if sentence is imposed or the person receives a fine, probation, or deferred adjudication. That means even if they take a plea deal that keeps the conviction off their record, then they are still technically convicted under the law. This law prevents the burglar from suing the homeowner for injuries that the burglar incurred in the process of committing the burglary. The burglar can sue the landowner for injuries if the damages arose from an act entirely separate from any act intended to result in the prevention of the commission of a felony or misdemeanor by the burglar, or apprehension of the burglar during or immediately after the commission of the felony or misdemeanor. Additionally, the burglar can sue for injuries if the damages did not arise from a premises defect or other circumstance that the claimant was exposed to as a result of the commission of the crime. Check out our Booby Traps on Property video for a discussion of protecting property in Texas. Basically, in order for the burglar to sue the landowner and win, their injuries must be caused by something other than an action to prevent the crime, apprehend the criminal, or some defect on the land that the burglar was exposed to simply trying to commit the burglary. Quick plug, be sure to like this video so YouTube will show it to more people like you. You may be familiar with derivative claims that allow, among other things, family members to sue and recover for injuries to a loved one. Well, rest easy. There is a special provision that prevents derivative claims by the burglar's family. That same prohibition against recovery that applies to the burglar also applies to claims brought by persons other than the burglar if the claimant's right to recovery results from an injury to a convicted person, including a claim for the wrongful death of the convicted person, or a claim for loss of consortium with or the loss of companionship of the convicted person. This means that family members cannot sue you for injury to the convicted person, the wrongful death of the convicted person, or the loss of the companionship of the convicted person if their right to recovery is barred, like we previously discussed. A claimant who is barred from recovery is liable to the person against whom the claim is brought for court costs, fees, and reasonable attorney's fees incurred in defending against the claim. That's right, if the burglar is a convicted person under this law, and they sue the property owner for injuries caused by their commission of the burglary, they have to pay the property owner's court costs and fees and attorney's fees in the case. As with other laws, this one has exceptions and pitfalls that need consideration before a case is filed or defended. Your civil litigation attorney can help you navigate the law and discuss how these laws can be applied to your particular case. If you want to know how to choose an attorney or how to call a lawyer, then these videos should get you started. From all of us here at Matthew Harris Law, we appreciate you sharing this video with your group of friends.